Okay, committee members and our guests from Namoi Water. Can everyone's back on? Yes, I'm seeing nodding, so that's a good sign. That is a really good sign. Okay, I now welcome our next witnesses, Ms. Jon-Maree Baker, Mr. Tim Napier, and Ms. Zara Lowien. I hope that's how I pronounce it, Zara, but I know you'll get a chance to correct me in a minute. So what I'll do is I'll start with Jon-Maree. If you could give your name, your title, and swear then either an oath or affirmation.
Yep, thanks, Mick. Jon-Maree Baker, and I'm the Executive Officer of Namoi Water. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Okay, thank you, Jon-Maree. Tim?
Tim Napier, Executive Officer with Border Rivers Food and Fibre in Gwydir. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you, Tim. And now Zara.
Hi, Zara Lowien. I'm the Executive Officer of Gwydir Valley Irrigators, and don't worry, Mick, most people have trouble with my last name. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Okay, thank you. Now, I'll give each of you in the same order an opportunity to make a short or brief opening statement. So we'll start with Jon-Maree.
Thanks, Mick. Namoi Water thanks the committee for the opportunity to present today. The exemption is a statewide exemption. It applies to floodplain harvesting, and it is a transitional process which is allowing the government to exempt floodplain harvesting take, particularly in the Northern Basin, as we transition across to a licensed process and scheme, as we've done for other licensing arrangements. We thank the committee for their time and interest in this issue, and we look forward to presenting on these matters.
Okay, thank you. Tim?
Chairman, look, again, thank the committee for their time and interest in this subject. I think of paramount importance in this, and one that hasn't been canvassed as far as I'm aware in any of the discussions or debates around floodplain harvesting, or indeed the exemption, is the history and how these things came into being. And I'd welcome the opportunity at some point to run through that history to give the committee a full background on how that came about.
Okay, thanks, Tim. And Zara?
Hi, thank you, Mr. Chair. I support the comments of my colleagues. Again, thank you for allowing us to present and elaborate more on our submission. You know, floodplain harvesting has been an important aspect of our organisations and, in fact, our members for a very long time, and Tim will explain some of that. But one aspect I did want to call out was the fact that between Jon-Maree, Tim and myself, there's more than 30 years of water policy experience combined, particularly focused on one of this aspect of floodplain harvesting. And it is the three of us that have been, in some cases, consistent representation on this issue over the last at least 10 years of when the government has been trying to enact this transitional approach to licensing, which we hope can continue and end with licenses in 2021.
Okay, thank you. And so we'll open up the questioning for the committee members. And just so our witnesses are aware, we have a number of committee members: Scott Farlow, Kate Fairman, Justin Field, Sam Farraway, Greg Donnelly. We had Robert Borzak, but he's just sent me a text. He's dropped out. He's in transit between Queanbeyan and Tumut, so he's dropped out, and he will try and come back in at some stage later on. And so for the committee members, the first person to send me the text to say they want to ask a question is Greg Donnelly. So we've got Greg on mobile phone.
Thank you, Chair, and thank you to all the witnesses for coming along today, and appreciate the submission made under the name of Namoi Waters. I've just got three questions, and we need to share them around amongst members, so I'll try and move through them quickly. first of all, could I just ask each of the witnesses, have their respective organisations received or sought and received independent legal advice about the legality of the government's regulation?
We'll start with maybe Jon-Maree.
Greg, thanks for the question. I guess in understanding your question about whether or not we've obtained independent legal advice about the legality of the exemption, we didn't feel that was necessary. The exemption is a transitional arrangement, which is included in the Water Management Act 2000. We've seen a number of transitional processes occur since 2003. There's quite a clear precedent where government is converting what has been a right through a work approval into a volumetric calculation, as we saw under unregulated water licensing processes, which was called the Volcon process that occurred in the 1990s.
Listen, I don't want to cut you off. My question is very specific. This is a particular regulation that we're reviewing, and that's the remit of this committee. And I do appreciate your historical context you're providing. But my question was very specific in regard to this regulation, which this committee is reviewing.
No.
Has your organisation, or did your organisation seek independent legal advice about its legality? And the answer to that would be sort of yes or no.
No, we didn't, nor do we consider it necessary.
Okay, thanks, Jon-Maree.
Sorry, the other two witnesses, if I could share. The same question.
Okay, Tim?
No, we haven't sought independent legal advice in the context of the exemption, but we've had conversations over time around it, as Jon-Maree referred to.
Okay, thank you. And Zara?
Thank you. And Ms. Lowien?
No, Mr. Chairman, we didn't seek formal legal advice, although I agree with the others. We didn't feel it was relevant on this piece of regulation, given the history of transitional arrangements in the past.
Okay, thank you. Greg?
Yes, on the top of page 4 of the Namoi water submission, which is number 7 to the inquiry, at the top of the page, I can just quote from it, it says, the embargo of the FPH and its removal and then reapplication without sufficient communication with affected stakeholders has resulted in upstream communities and the FPH being misrepresented. I'm just wondering if Ms. Baker could elucidate on what that means. What is the misrepresentations that have taken place?
Thanks, Greg. The misrepresentation that occurred as a result of application of an embargo without any detail in how it would be implemented on a Friday afternoon and then applying that across a whole range of farmers and farming enterprises resulted in significant confusion about how the embargo applied in terms of managing a farm during those circumstances. In relation to your issue about upstream communities being misrepresented, my point was really about the volume of extraction that occurs in relation to floodplain harvesting and when opportunities of floodplain harvesting occur. I believe that the New South Wales Department, in applying that embargo, undertook an assessment of the potential risk of extraction arising from any rainfall that may have occurred preceding the event. And I guess my concern is we certainly didn't see any transparency about that risk assessment. And in terms of downstream communities, there is an unquantified and unrealistic expectation that rainfall that occurs in those circumstances substantially contributes to downstream flow outcomes. And I think quantifying that particular issue is important for government to resolve the misunderstandings around floodplain harvesting and the flow volumes that are extracted as a result of events that occur. And as we demonstrated in the farm tour, many of our farmers do not access water until we have a high flood level, and that's why it is actually known as floodplain harvesting. So I think that's really, Greg, probably my answer, unless you'd like me to expand further, that it's a lack of...
No, I think that's good, because on the previous page you've actually got some useful information reflected in a very helpful graph in terms of the flows. And I just find it curious that the government could have got it so wrong, that in terms of the information being communicated, because I mean the data is the data. It's obviously well known, and to have significant communities upstream and downstream being confused, I think is very unfortunate, because you end up with a situation of almost farmer versus farmer, so to speak, or grower versus grower. And I mean, that's just something which is not acceptable. And listen, can I just take you to the bottom of page 4 of the Namoi Water submission? It says in the last sentence, leading in, this would substantially be improved. Departmental staff were based in regional areas to be on the ground to work with the community on these issues. And it goes on. On this matter then of the departmental staff being available on the ground, which is critically important, is it to be implied from what you're saying that there are not any or many or only few departmental staff available to be on the ground to provide this type of advice and assistance?
Greg, look, I think in relation to the number of departmental staff that actually have lived in a rural area and lived in an area where the water resources that they are actually managing are few and far between today. Unfortunately, we've transitioned from what was a regional management structure, certainly through the 80s and 90s, and as we were developing our water sharing plans, and we've transitioned to a very central agency where, very few people actually have real on-ground knowledge about those issues, that they are significantly contributing to decisions that impact rural communities. My point is really, I think, if we are to make better management decisions about natural resources, actually having people that are based in regional areas, and given we've just had a fantastic experience through COVID of everyone working from home, it demonstrates that it is feasible to have senior level staff actually based in rural areas and contributing to those conversations and better understanding of issues, both at a regional and at a state level. So, I think there's a significant scope of opportunity to have staff placed in regional areas, and that allows for better decisions to be made. And a really good example is, understanding how flow dynamics, particularly in rivers such as the graph that we've presented, the Namoi River is the high point of the bank. The overland flow, the majority of the flow that contributes to downstream outcomes actually comes from the river itself. And we need a substantial flow for a floodplain harvesting event to break out from the Namoi River. And just understanding the importance of that in context of individual rainfall events becomes really important.
Yeah, of course. Thank you. Chair, I've got some more questions, but I'll pass on.
Okay, thank you, Greg. I just want to follow on, Jon-Maree, if I can, a bit about the communication. It's raised in just about every submission that there was very poor communication around the implementation of the regulation. And in your submission, in the Namoi Water submission, if I quote page 2, second last paragraph, you say, and the immediate removal of the exemption via a section 324 embargo caused substantial distress for water users. So clearly there's an issue here around the distress that's caused. I guess that emanates from the lack of communication. And would having more people based in regional New South Wales from Department of Water, DPI Water, or whatever they're called today, would that assist with the communication process?
Oh, Mick, absolutely. I think it would. I think under Labor, if I might say so, we had substantial staff in regional areas that understood these issues and therefore understood the need for communication and how you could actually effectively communicate in regional areas with people. The embargo was applied at 4:38 on a Friday afternoon. All the media had shut down, and obviously, there was an inability to communicate via radio, and therefore it was left to groups such as northern water users to communicate directly to farmers. And I think it's a partnership between those that are based in regional areas and the relevant agencies in understanding how we actually communicate in an effective way. So I think absolutely we need to rethink that process. But I can't stress enough the distress that was caused by the removal of that embargo. I believe actually set up what Greg was indicating was farmer versus farmer due to the misinformation and the perception that the event was being somehow mismanaged. And ultimately that comes down to being able to clearly articulate in an embargo event what the public interest test is and the process for applying that. And then going that one step further in actually being able to, as events are managed, being able to communicate that clearly and concisely to the communities that are actually affected by those particular issues. And ultimately our goal is to ensure that when we do reach critical needs, that we have the right process and structure in place to be able to communicate those issues well, so that not only communities where we work and live in the Northern Basin, but also downstream communities are listened to and understood, and their concerns that they've raised, that they feel like they've had opportunity to contribute to and have a good understanding. And I think I would highlight a good understanding because Mick Kelty in his report has highlighted we have a toxic water debate, and unfortunately the misrepresentation of the media is contributing to that issue because water is complex. So we really need to, I think, rethink how we engage with communities, both up and downstream, to resolve that so that everyone gets the best outcome. Okay,
thank you. And I wouldn't mind just asking Tim and Zara your views around clearly the communication of the regulation has been an issue. I mean, people wouldn't raise it in the numbers they have if it wasn't. Can I ask maybe Zara first and then Tim, what is a better way to, in your mind, what would have been a better way to have communicated this regulation and the subsequent exemption?
Thanks, Mick. I think for this one was the communication issue was conflated through timing. If they had, the regulation has always been foreshadowed within the floodplain harvesting policy. And just because it's been foreshadowed, we would have expected or would have hoped that the department could have briefed individual water users, other communities, Parliament, a little, well, actually brief them full stop, rather than just because it's sitting in the policy doesn't mean it is, one, going to be potentially enacted or when it's happening. And so I think where they failed was in timing of that. It's sat there since 2013. It could have been enacted at any time, except for some reason. And I thank the Minister for actually actioning that step to provide clarity for everybody. But that happened at a time when we were in a critical and, 100-year drought. And that's then conflated this second issue, which is the separate order, which was the temporary restriction order that came thereafter. So I think, going back through, and I believe this committee put forward the regulation guidelines, there are some clear steps there that could have been done in an easy, simple manner with an explanatory note, which could have happened in much earlier. than what we got on the Friday. And then subsequently, we could have had discussions about the temporary restriction previously. So with other forms of access, for example, regulated entitlement out of a dam, when a temporary restriction is going on, it can have potential market impacts. So I appreciate that you don't forewarn that. The view that putting a temporary restriction on floodplain harvesting that can't be accessed unless we're in a flood, as Jon-Maree's pointed out, it's got to break certain points in each of the valleys to be initiated. It's not something we can create or call water on for. So I think earlier discussions on whether there was intention and what that would look like, and explanation on how the difference between passive and active might mean and what it meant for rainfall runoff within your irrigation fields, things like that. Those discussions could have happened with water users well in advance rather than via a text message. And then have that communication of a text message and then have no one available to explain that except those industry groups. And we can't sit in a position and provide advice to our members without clearly understanding those definitions ourselves. And it's evident that there was a lack of communication around that. And that's where the frustration stems from. So I think action and following due process on the regulation, and then being more upfront and transparent about their intent and how they would embargo if an event, if they needed to, could have helped alleviate. And I will reiterate Jon-Maree's comments of significant stress for people. We have been in a drought, just as most of New South Wales has been. Most people don't have staff available because of the drought. They've got rid of all of their casual staff. And so farms have been left idle with no consideration of water occurring. And then to be told that now you've got to exclude water and not even understand how to. There was a staffing issue. There was a lack of understanding. And then the third compounding impact is we understand now, and we're all living in a water environment with a very firm and fair natural resources access regulator. And that uncertainty and that not clearly understanding what they could and couldn't do in some circumstances was very distressing for individuals in a really difficult time. And I think that is where the frustrations have come from industry in particular.
Okay, thank you. I'll get Tim's views and then I'm going to go to Justin, who's indicated he wants some questions asked. So Tim, your views around communication?
Yeah, thanks, Mick. Yeah, look, endorse the comments of John and Zara. It was poorly planned. It certainly was a matter of timing. It could have been done far better and not left until last thing on a Friday afternoon to actually invoke these things. We were in a slightly different situation because our event, the timing of our event was different. But we had towns in our valley that were within weeks of running out of water ourselves. So we are more than acutely aware of the impact of the drought that had impacted everybody. But the communication that we had on Friday afternoon consisted of an email and a text message, followed up by a phone call in some cases, which was then followed over the weekend by us trying to get onto departmental staff to try and get some more detail around what was actually happening. More confusion was created by the lifting of the partial lifting in a minority of cases. I understand wasn't in our valley, but when that became known, that certainly caused confusion about what the hell's actually going on. Back to Jon-Maree's earlier point about lack of people on the ground. In the past, we had regional management and regional staff. Those people were on the ground, they were embedded in the community, they knew exactly what was going on and who to speak to if they didn't know. Now we have the centrally decision-making system that has become problematic, and I think this shows acutely the area of problem that has occurred in this case because of the lack of the ability to both prepare and to communicate during an event. And I think I make the observation that the decline in the performance of the New South Wales Department can almost be traced back on a timeline to the withdrawal of those regional staff from the regions.
Yeah, I probably agree with all of that, particularly the regional staff being located in regional New South Wales. But, you know, hey, I'm a bushy like some of the others on this committee. Can I thank you for that. Justin?
Yeah, thanks, Mick, and thank you for making the time to be here and explain this to us, to everyone. I'm still struggling to understand the rationale for the regulation and where the key issues are. The Irrigators Council, before in their testimony, were very careful to try and say they wanted to keep the regulation and the embargo on orders separate. They saw the regulation as a transitional arrangement that was always flagged. Jon-Maree, in the Namoi water submission, you say on page 2, take under the Water Act 1912, under various parts, approvals was exempt from requiring a licence, and the transitional arrangements provided that until licensed through the Healthy Floodplains project, the exemption would continue. So I take it from that really it's a continuation of the status quo, that the regulation in effect has not had any substantial impact on your stakeholders. Is that right?
So just, Jon-Maree, did you get all that? Because Justin did fade out at one point. Did you get that? Yeah. Okay, do your best.
No, all good. Justin, I guess in terms of the rationale for the regulation is that we now have a new natural resource access regulator, and the concern is that for the regulator to undertake proper compliance, there needs to be quite clear, specific regulations within the Water Management Act that clarify how the regulator can implement compliance that relates to this issue. So, look, in terms of the transitional arrangements, you know, the fact that the department would have undertaken, I would assume, their own legal advice that informed the decision to apply the exemption, it had always been intended in the policy regardless. So I think there are two aspects here. One is the requirement for the exemption to cover transitional floodplain harvesting take, and then the other is for a general exemption as it applies across the water resources. And my understanding is that we will still require a general exemption regardless. So I think in that context, the rationale for the legislation is quite sound because it does currently exist within Water Act 1912. Is it required prior to the licensing of floodplain harvesting to cover take from licensed works under the Water Management Act? We haven't sought legal advice on that particular issue, but I would assume that the New South Wales government would have done that as part of this process. So I agree with you, Justin. I think on one hand, we have a transitional arrangement, but ultimately under the Water Management Act, it was always intended that there would be a general exemption because this is a statewide policy position. So my understanding is that it is necessary. It was always intended to be implemented, and it does provide the regulator with the necessary clarity and clarification in relation to how they would implement compliance that relates to works approvals or flood work approvals and take that occurs on floodplains.
I think we're getting a bit closer to the answer here. There was some media a month or so ago which suggested that NRA had expressed a view that floodplain harvesting, some elements of it may well have been illegal, and that with some floods expected, they might have indicated that they were going to undertake enforcement actions, and so this regulation was necessary to clear up the status of the exemptions and bring it under the Water Management Act. Is that effectively what you're saying as well? There is a different disagreement internally and potentially even between Northern Basin and Southern Basin irrigators about the legality of floodplain harvesting under 1912, and that's been tried to be cleaned up under this regulation.
No, I think, Justin, the issue that that you've highlighted is specifically relating to the general exemption that needs to apply, and it does apply under Water Act 1912, and this exemption does provide for that under Water Management Act 2000. So in terms of a general exemption, absolutely, it's the regulation does continue that, and so should be supported. In terms of the issue that you raise in relation to NRA's view, ultimately they, as a regulator, would have their own internal processes, and ultimately that's for New South Wales Government through the Department of Industry, Environment and Water to resolve whether or not there is a gap, because certainly this is not the only area of water regulation that the regulator now has highlighted, that there are some ongoing issues in relation to how we've transitioned across certain aspects of water management law. So, you know, that's NRA's job, Justin, as you and I both know. We want a functioning regulator. They've raised a concern that doesn't necessarily relate to floodplain harvesting being illegal. So, you know, I think we need to clarify that particular point. But ultimately, my understanding from the beginning of this policy, it was always intended to have a general exemption continue, and that's what this piece of regulation actually does.
So the real frustration then is not so much with the general exemption regulation, but is then how it was used to implement the 324 embargo, and then there's some confusion around the temporary exemptions to that again. And this is, I guess, for all of you. Were you surprised that an embargo was being put in place? Because we know that, you know, there's been discussions about the general regulation and the policy for a long time. Everyone assumed it would rain again at some point. Had it never been raised with you, the possibility that an embargo on floodplain harvesting could be put in place as part of a first flush event? Is that where the surprise came from?
Look, Justin, I can speak from my own perspective. I was not aware that there would be an exemption applied to then result in an embargo. So certainly we were surprised. And I guess that's why, in terms of our submission, we've raised the issue of transparency around the public interest test of applying embargoes is critical. It was a commitment of Niall Blair when he was minister. And, you know, in terms of the Water Amendment Bill in 2018, quite clearly on the floor, there was a commitment that government would undertake proper public consultation on the public interest test to ensure that issues like this were better addressed and better understood by the general community. So from Namoi Water's perspective, we were not aware that an embargo, the exemption and embargo would apply. The timing of that, as you've already indicated, we raised in our submission. But the terms of reference for this committee specifically relate to the regulation and its necessity, and then the impact of it. And so in terms of answering those questions, I guess we feel that the general exemption was always intended, and as we move forward, you know, I'm quite sure that government would be keen not to repeat the poor timing. And I would suggest there is acceptance that really ultimately the assessment of floodplain harvesting take and risk probably should have been more transparent in terms of the decision making around that, because that would have then led to addressing some of the misperceptions that floodplain harvesting took 300,000 megalitres of water in that last rain event, which is, you know, in fact incorrect. And we don't have a department or agency, you know, clarification on the licence volume of floodplain harvesting yet to address those issues. So ultimately for communities, particularly in the Northern Basin, where floodplain harvesting has developed because government did not build significant headwater storage, and we ran into practical issues around delivering water. Floodplain harvesting, in terms of its historical context, and I know I'm answering this in a very long-winded way, we just need to reflect that it has developed arising out of government policy positions for over 30 years. And that informs how we've got to where we are now and why it's an important part of the landscape, because floodplain harvesting and diverting floodwaters has occurred by graziers and by landholders in numerous different ways for, you know, decades now, and it's been something that government has recognised. And this process is actually about licensing that so that we can volumetrically account for it as we're required to do under the National Water Initiative.
And Justin, before you go on, I wouldn't mind getting Tim and Zara's views on that question.
Yeah, happy to, Nick.
I'll go if you like, Zara. Yeah, look, Mick, in terms of the embargo, we absolutely anticipated an embargo to be put in place, but it has to be understood that this is the first time that it's ever been applied to floodplain harvesting. Historically, embargoes have applied to supplementary take, and we fully anticipated that because of the depths of the drought that an embargo would be in place to limit that. We understood that. We knew that was going to happen, but the one concerning floodplain harvesting was completely out of left field, and because it had never happened again, never happened before. So I think it's important to understand that.
Yep. Thank you. Zara?
Thank you. So I think if I can just raise a couple of points and reiterate something that John said earlier was about the transitional approach and the regulation first, and then I'll move to the expectation of whether floodplain harvesting would be embargoed. But the key aspect in terms of the foreshadowed exemption, which has existed in the floodplain harvesting policy, one area which may explain why it happened is we all know water's complex, but unfortunately in New South Wales, because of a number of legacy issues, we still have significant number of approvals as well as access licences and other forms of rights that are sitting in the Water Act. And so the clarity provisions were required to move all of that, those remaining systems, particularly for floodplain harvesting. But we still have some unregulated access licences that sit in the Water Act as well in some of our areas, is to start to make that clearer for everyone going forward. So I cannot reiterate that enough, is that whilst it was foreshadowed, it does also provide a much easier regulatory space also for water users, but also the regulator and government going forward, knowing that a fair portion of that in the northern parts in our 5 valleys would then transition again to a licence. The key aspect of that too is that the original Healthy Floodplains project, which started around about 2013, had a staged approach, which had valleys stepping on different timeframes, and so they needed the transitional arrangement to ensure that all of those valleys were progressing without undue, perverse impacts of what stage they were at in part of the Healthy Floodplains program. And so that's really important. The reality is that we're now in our 2nd or 3rd extension, and we're 12 months out potentially of licences. But I believe they are some of the reasons why this transitional arrangement was to be put in place. And to highlight that, I believe the Gwydir and the Border Rivers have a floodplain management plan in place, and the Barwon and Darling have their floodplain management plan in place, and Jon-Maree, Lowien Napier might have been approved. And so those are the key instruments which move some people's licensing approval process through to the Water Management Act. So that's just providing some clarity for people.
Okay.
On the question of whether we thought an embargo would ever happen, we had done some risk analysis and understanding to understand that under a licensing regime, we could expect a embargo on this form of take. As I said earlier, we were, and just like Tim's Valley, most of our valleys had areas, and we had members which were short stock and domestic water, as well as we knew towns just downstream of here were at critical supply. What surprised us is that the movement to floodplain harvesting restriction almost ignored or misunderstood the way floodplain harvesting occurs, and because we know it needs a flood at a certain height at a certain extent, and the last time we had full access or all of the northern regions were floodplain harvesting was back in 2011-12 when we had water from the border down to the Macquarie marshes, and it was a sheet of water flowing, and Menindee Lakes was surged multiple times because it couldn't contain its 100% full level. So we just thought it was a little bit strange from that aspect to put on an embargo when there was an unlikely chance at that time that there would be a flood, because it requires a significant amount of water. But as it turned out, we had a very small, isolated and very flashy event because of the intensity of some rainfall in a couple of locations. But we weren't considering that would even be a step that the government would take until that week.
Okay. Thank you. Justin?
Thanks, Mick. I'll let someone else have a go. If we've got time, I do want to come back to the volumes question.
I think, well, at this stage, you should keep going.
Okay. Again, I'm happy for anyone to answer, but I guess, Jon-Maree, because it's picked up in the Namoi water submission specifically with that chart, look, there's been commentary in the media about the volumes being much greater than what the government has currently said the maximum amount of floodplain harvesting take over that period was, which I think they've said was about 30 gigalitres. Others have put it at hundreds of gigalitres. I just want to try and get to the truth of how much water this is. Why are you so confident that it's a relatively small amount?
You dropped out again, Justin, right at the very end.
Oh, sorry. The end question was to Jon-Maree. Why are you so confident that floodplain harvesting is a relatively small volume compared to the amount of water that ultimately flowed down the rivers?
Thanks, Justin. So again, it goes to applying context of when floodplain harvesting opportunity arises, and you would have to have a substantial rain event over a sustained period for overland flow. And I guess it comes down to, there are two aspects of floodplain harvesting. One, it occurs from water that breaks out from the banks of a river. And as we demonstrated, at the Mile Vale breakout, you have to have a substantial event to occur for that. And the floodplain basically is, 50 kilometres long and 25 kilometres wide. We have a flood management plan that ensures that we maintain connectivity. So in terms of assessing the risk of floodplain harvesting and the volumes that are taken, I can't really comment on data and projections that we actually haven't seen, Justin. So I'm not aware of, it's easy to throw a number out and say it's hundreds of gigalitres, but ultimately you have to back that up with some level of assessment. In terms of government assessment, they've used satellite imagery, and they now have a tool where basically, in terms of compliance for this process, government used satellite imagery to assess starting storage coverage in terms of surface area covered, and then assessed end of event surface area covered, and where there had been a change greater than 20%, that then flagged for further assessment. In terms of assessing floodplain harvesting take from satellite imagery, if I have a swimming pool and I fill it up with 15 centimetres of water, is it full? And the answer is no. I have 15 centimetres of water at the bottom of my pool. So the perception of floodplain harvesting, I think, is very much from if a storage is covered with water, that represents a significant volume of take, which is fundamentally incorrect. So in terms of how we can be sure it was a small amount, we rang every farmer in the Namoi that had an opportunity to take overland flow and asked them how much water they extracted while the embargo was lifted, and asked them how much water they had in their storages so that we could help quantify that start and end balance of what the volume might look like. So that's really, I guess, the process where we're reasonably confident that the volume of extraction, because as it relates to the volume of the event, which did not include a breakout from the Namoi River, it was overland flow that occurred from 150 millimetres of rain that fell overnight And so basically had a situation where the majority of the flow came across land and is not water that would have ever have contributed to maintaining downstream flow outcomes. So I think really, again, it comes back to local knowledge within each catchment, which operates very differently in each individual flood event, depending on rainfall. And a really good example, Justin, is we've got a farm that's got 15 rain gauges, and from one side of the farm that had 10 mil during that same event to the other side of the farm that had 150 mil and then received another 50 mil on top of that. Each farm and the water that runs off it is going to be different, and floods occur differently based on whether or not the antecedent conditions are, a crop in the ground or grass across the country or bare, which has, as we saw in the last event, most country was bare. So there was a substantial shedding of water, and most of that came off irrigation fields, which was rainfall runoff.
Just one quick follow-up then to that. Let's talk about the overland flows for a minute, because I get the sense that this is where some of the confusion comes from, and it can be a substantial amount of water. I understand, and you've said very little of that would have ever been able to contribute to downstream flows, but I think we know that the size of the properties and the way they are designed is to maximise gravity-fed water moving over the farm, through the landscape to capture it. I mean, just so I understand, that's what I understand the government calls passive take. Is it your understanding that is using that water, capturing that water, diverting that water, is that considered floodplain harvesting? And do you think that is that water use or take going to be licensed as part of the floodplain harvesting policy?
Mick, it's going to take a long time to answer this question. So
I'm happy to put some of that on notice if it's useful.
Yeah. I was going to say, John, can you just put some of that on notice, because we're moving closely now to the cut-off time, and that's information that we don't want to miss. So if you could maybe take it on notice and provide that. And Justin, so Kate's also got a couple of questions as well. So
go for it.
Okay, right.
Okay,
Kate.
Thanks, Chair. Just a question back to Jon-Maree, actually, in terms of can you hear me? Yeah. In terms of one of your responses just then to Justin's questions, you said that after the embargo event, you contacted your members to ask them to estimate how much water they took during the embargo. A couple of questions about that. Has that information been given to the government to check against the satellite imagery you've also referred to? Has NRA asked for that information? And that was, I assume, I think it was the 30 gigalitres that you have referred to. Is that right as well, like in terms of the total of that amount?
So Kate, obviously multiple questions, and Zara and Tim can probably jump in as necessary. The Natural Resource Access Regulator undertook compliance visits recently, and what we knew, because there was an embargo that had been applied, and because of the lifting and the whole confusion of how the embargo worked, we wanted to ensure our members understood how they could best, report when it came to the end of the event. So that process of internal quantification of the number was really to address community concerns that it was a substantial volume of water that would have contributed to downstream outcomes. So we've retained that number within Namoi Water. We know that government have undertaken their own assessment through the satellite imagery, and they've undertaken a quantification of floodplain harvesting as a result of tools that they've developed. And I think that that's an area that will progress over time, where that sort of satellite imagery can continue to provide a validation point in the volumes of take, so long as it is clarified and validated at a farm level, which has now been done through the NRA visits in every single Northern Basin catchment. And that's the process that we would support to ensure that there's confidence in what volume was actually accessed during the event.
Can I just a quick question though, sorry, just to jump in. So you're talking about NRA visits, but you also specifically said that you asked all of your members exactly to feedback to you what they think they took during that period. So I assume, the question is, have you passed all of that on to the government? Has the government asked for that, or has NRA asked for that? The visits are one thing, but the information that you specifically got from your members, it's a question as to whether NRA has actually asked for that to really quantify what was taken during that time.
Yeah. So no.
And Jon-Maree, just so you'll answer that one, but then Zara's also indicated she would like to respond as well. So Jon-Maree first, then Zara.
Yeah. So basically, Kate, we were asked to provide our understanding of floodplain harvesting access during the event to address the issues of confusion around the number. So we've certainly provided that information in a format of here's what we understood was accessed during that event. It hasn't been provided to NRA because they don't request that they have not requested that information because they are an independent regulator, and I would not expect them to request that information from us or for them to accept information that relates to that event. They're required to undertake their own independent assessment, as it should be. So certainly, look, we have provided an estimate to the department in terms of what we think was taken, but in terms of quantifying that at an individual farm level, we haven't provided individual numbers of each individual farm's take for that. So we just aggregated the number that we estimated through that survey of our members and have provided that.
Zara?
Yeah, so I think some of the context around that I think is really important because we did the same process as well. And it was a commitment by each of our groups that we had with our members that if an event occurred, a floodplain harvesting event, regardless of the conditions at the time, that we would trial the proposed monitoring strategy for the floodplain harvesting program. And so that was the objective that we did, and we encouraged that over that week and that time. And that really helped to better inform our understanding of how that monitoring process would go forward and be prepared for that new space of having that approach under a floodplain harvesting licence. And so we did a similar approach to Namoi water. We asked people to voluntarily provide that starting balance and that ending balance at certain dates. And we did have, and we're still waiting to have a discussion where we can understand more the government's approach. And so we've been requesting with plenty of stakeholders a technical report on how the satellite approach was done. And we would have hoped that that could have been available so we can interrogate, because this is the space we're moving to. And I think this is a fantastic aspect of this, is that we did trial for the first time voluntary monitoring on the ground, which would be part of the licensing program going forward. And we did, the government trialled their new technology, which is bringing two forms of existing technology together to estimate volume. And so we think it's important that we have a chance to validate and calibrate that process, of which John's correct in the NRA visits that have been occurring lately. They are going and validating the volumes in store and the records. And some of those records are very much those ones that we encouraged and asked for at the time. We're yet to have detailed discussions with the department.
Kate, before you go on, can I just get Tim's views on that as well?
Yeah, look, endorse the comments of the others. And again, our take in this particular event was very limited because by the time the embargo was lifted in the New South Wales border rivers, the flow had essentially gone. I think we had a day and a half right on the tail. So, yeah, but look, the sooner we can get to open and transparent reporting of exact volumes taken, at very short notice, then the happier we will be. because the what's causing us the pain is the disinformation that's being peddled by those who don't know, and are just throwing numbers out there for the sake of speculation, and that is doing us enormous harm.
Yep.
Could I just
thank you, Kate.
add one thing, Mick, and some of Justin's questions before? The department have provided some further analysis on the flows that occurred during the February event, and further explanation on the floodplain harvesting component. So I think that's important information that's coming, that is now available. There needs to be more detail there, but I must say it is July and we're talking about an event in February, and I think in a space where we're licensed, where there's a monitoring program in place that, rather than being voluntary, is mandatory under a floodplain harvesting licensing regime, I think it's really important that we have this information in a more timely manner, so that there isn't this question of how big is the volume, is that water that I can see in a satellite image, how has that been taken? We'll have clear understanding of that in a regulatory regime, which includes monitoring and compliance requirements for individuals.
Yeah, I see Tim was nodding as you were speaking, so I think that means he concurs with your views. Is that right, Tim? Yep. Okay. Kate, have you got any further questions?
I'd love to, if I can, just to get clarity just on that question. So the department did the department ask you for just the total take in your respective valleys, or were they after individual takes? I think, Zara, you suggested that this was an opportunity to trial some of the monitoring. Therefore, did the department want to have access to what that looked like at an individual property level? Or were they just coming to you saying, what's the total take in your valley? Were they not seeking any more information at all?
Could I be clear? The department have never requested us to provide any monitoring at all, nor has NRA. We, as an industry, collectively decided to undertake and to test the monitoring strategy, which we understood at the time to be going to be into place, and we're still waiting for that final version to be announced. And so what we did is take the opportunity to provide them the amalgamated information. But we have said, and we've requested a number of times, that we would like to sit down and have a discussion with them about calibrating that process, which I think is really important to the technology, and that has yet to occur. This has been industry driven.
Yep, good, Kate. So I've just got one question before we finish up. Essentially, so it's been put this morning that we could, if the disallowance motion went ahead and the regulation was overturned, that in effect the arrangements were in place before could still continue on until such point that the legislation comes in place. Accepting that it's been pushed back a few times now, this bringing in the legislation or the formalised requirements, how long do you think this regulation could hold up if it goes out beyond the government's proposed July next year? So two parts really. How long can it go for? And two, if the disallowance motion was successful in the House, in the upper house, what does that effectively mean on the ground? So I'll start with Zara, then I'll go to Tim and then Jon-Maree.
Okay, so my understanding, the regulation didn't have any sunset clauses in its timeframe, but Jon-Maree was correct in her initial saying that this is the first one, that there needs to be further regulation later on to address the remaining parts of the state that are not licensed. And I think that's really important to foreshadow to the committee and to Parliament, is that there is potentially another piece that will come through which will repeal this. And for what happens on boots on the ground, I think for largely our region where we sit within transitional arrangements, we haven't seen water supply works approvals for floodplain harvesting be issued yet. So the majority of our approvals sit within the Water Act still. Where there is a lack of clarity is for those who have Water Management Act approvals announced. And that's that statewide implication where other areas and maybe sections within some of the Northern Valleys have a Water Management Act works approval and that's where the clarity is really needed. So what it does is potentially highlight that statewide issue for some people, knowing that the transition or that licensing for the Water Act covers most of those most of those water users in the northern parts.
Okay, thank you. Tim?
Mr. Chair, look, I'm the lawyer, but my understanding, and we've always been assured that the transition requirements would stay in place until such time as licensing is completed and the transition is completed. So at this stage, that's July next year. So that's what we've been assured ever since this process started.
And that's the date you're working to?
That's the dates everyone's working to, I believe, yes.
Okay, thank you. Jon-Maree?
So Mick, I think your first question about how long the transitional provisions can stand up has probably been answered sufficiently. In terms of the impact on the ground, really this is now extending into the area of compliance. What we don't want to have are regulations that don't provide clarity to a modern functional regulator to be able to implement compliance. And so my understanding is that this exemption actually provides significant clarity for the regulator, and it reduces the amount of potential for legal interpretation in relation to how the exemption applies on the ground to a range of different forms of take that have transitioned across from Water Act 1912 across to Water Management Act 2000. And ultimately, you know, the test of that is in the legal system. But I certainly wouldn't want to place farmers who have done their very level best to comply with the regulation that's been clearly communicated to them by not applying this exemption. It potentially puts them at risk. And so my understanding, you know, from impact on the ground is this is actually about providing security, not just for northern farmers, but for farmers and water users across the state. And so I think in terms of the outcome that the exemption provides, we should really be focused on that. And I think that stands to itself to recommend, particularly to the upper house, that the regulation should pass.
Okay, thank you. Well, that ends the session. Can I just thank you for attending, Zara, Tim and Jon-Maree. Jon-Maree, I just want to again thank you very much for the time that you took last week to provide a the digital or the virtual tour, so to speak. We were actually all intending to get out and have a look around, but COVID-19 sort of gazumped that process. So I'm really appreciative on behalf of the committee for your time and effort last week. I do believe there was one or two questions taken on notice, and I just want to flag the question that Jon-Maree took on notice from Justin. I would also like that question to go to Tim and Zara as well for their comments. I think it's pretty important. So the Secretariat will be in touch with you about that, and the committee's resolved that you have 14 days to turn around a response. So thank you very much for your time with us today. It's been much appreciated. And just for the committee members, you all have to leave this meeting now, because when we come back after lunch, it's a completely new meeting to resume the hearing. So thank you all very much.
Thank you.
And we'll talk to you all later on.
Thank you.
And we're adjourned until 1:15.
Thank you very much.